When managing a SMSF, it's important to have a clear understanding of the relationship between the SMSF and trustee company. Challenges can arise if the trustee company's compliance is not maintained, whether due to unpaid annual review fees, overdue penalties, or other compliance failures, and if company is deregistered, and that raises questions. How does this impact the validity of the SMSF, and what steps should be taken to ensure the fund remains fully compliant? So, deregistration of trustee company impacts your SMSF? Yes, absolutely. Loss of control of SMSF assets. All property held by a deregistered company will automatically vest in the name of Commonwealth of Australia. Section 66 of the CISA mandates that an SMSF trustee must be a valid entity. If the trustee company is deregistered, the SMSF may be deemed non-compliant by the ATO. Any money held in the fund's bank accounts may be lodged with ASIC's unclaimed monies account. The SMSF will no longer be able to accept employer contributions or superannuation rollovers. This can result in the suspension of any future contributions to the SMSF until a new trustee is appointed. A non-compliant SMSF can trigger substantial tax implications, including the loss of concessional tax treatment, and instead be taxed at the highest marginal rate. Does deregistration mean your SMSF will fail? Not necessarily. According to Section 17A of the SIS Act, the ATO grants the SMSF a 6-month grace period to restructure and restore compliance if the fund has not met the basic requirements. The case mentioned offers a clear example of what happens when a corporate trustee is deregistered. Facts: there was a sole member of the Bolton's superannuation fund, and member passed away in June 2015. Following her death, the trustee company became inactive and was deregistered. This left the fund in a state of legal uncertainty, with valuable assets under the control of a deregistered company. Letters of administration were granted in 2017-5. The administrator asked the court for two things: to appoint new trustees for the fund, or reinstate the company. The court decided, given the complexity of the thing, it was appropriate to appoint new trustees. This case shows the importance of maintaining a company's registration and ensuring there is a succession plan in place. The Bolton's case provides several key lessons, includes maintaining trustee company registration, clear powers for trustee appointments, succession planning, and purchase trust deed from a reputable service provider. If you discover that the corporate trustee of your SMSF has been deregistered, immediate action is required to restore the fund's compliance. Appoint a new trustee company, update the trust deed, notify the ATO, transfer assets to the new trustee, review fund compliance under Section 35B of the CISA Act. You can reinstate a deregistered trustee company as well, if you do not want to appoint a new trustee. Section 601AH1 of the Corporations Act provides a pathway for reinstatement under certain conditions. The process is not straightforward. Specific criteria must be met, and detailed explanations must be provided to ASIC through Form 581. The deregistration of a corporate trustee can pose serious challenges for your SMSF. Swift action is essential to avoid compliance issues. Whether appointing a new trustee, reinstating the company, or change it from corporate to individual trustee, ensuring ongoing compliance, expert advice is vital. To purchase a special purpose company, go to your document manager, select company registration, fill out the application form, and choose the right option. To purchase a transfer from one corporate trustee to another corporate or to an individual trustee, please select MSF Tools. Thank you for your attention. If you haven't registered yet, please sign up at trustee.com.au.